This short video would discuss the Australian case of Dow Jones and Gutnick, specifically its facts, the judgment made, and what the overall impact it has to Australia. Dow Jones and Gutnick is a landmark case because of the issues it had to resolve, which was whether Australian law could be applied in regards to internet content that is defamatory, even if the content is subject to another country's law as well. So what's the story of this case? Well, Dow Jones the appellant is a New York headquartered company where it publishes magazines, as well as publishing it through an internet server in New Jersey, America, known as Barron's Online. The website Barron's Online gave internet access to content from Barron's hard copy magazines. During the 28th of October 2000, Barron's published an article about Joseph Gutnick, the respondent who was an Australian businessman. The article contained stories about Gutnick that would question his business probity. In response to the publication, Joseph Gutnick sued Dow Jones under Australian law, as he alleged to the fact that the article that was referencing him was defamatory. So what was the main issue that the High Court was dealing with? Well, in this case, it was a question of whether Australian law had jurisdiction over the online defamatory material in regards to Gutnick. The High Court would need to figure out where exactly the article would be considered published for the purposes of defamation. In other words, was the article considered published where it was uploaded in New Jersey, America, or was it considered published where the content was accessed specifically in Victoria, Australia, where Gutnick's business is centered in? If it was considered published when it was uploaded in the US, the High Court of Australia wouldn't be able to extend its jurisdiction to coincide with existing US jurisdiction that handled defamation. The High Court's choice concluded that the Australian jurisdiction is applicable due to the fact publication that causes defamation occurs when the content is accessed, rather when it was uploaded, so it mattered little if it was uploaded in the US as long as the defamation occurred in Australia. The reason why the court held that there was clear defamation in regards to the internet content was because it was clear that Gutnick was a resident and a businessman at Victoria, Australia, who needed to maintain a good reputation for his business to go well, which obviously means that he would want to avoid any sort of defamation in that area. Unfortunately for him, 400 Australians, which around 300 of them were from Victoria, had already read the defamatory article. This resulted in clear defamation occurring in Australia because of the publication. Therefore, Gutnick was entitled for compensation. It's important to note that the material must be accessed or communicated in a jurisdiction where the plaintiff has a reputation. This would mean that such defamatory would only happen if the plaintiff has a reputation there to begin with, while also meaning that one publication can potentially be subject to a range of different defamation laws, even if the plaintiff is no resident of that area. So in conclusion, any publisher that published material that may potentially be defamatory may still be liable and be pursued in other jurisdictions where the harm has occurred. This case overall also makes it clear that Australia can establish its jurisdiction if an Australian resident suffers harm from online content, including content made outside Australia.